All right, good morning. I'm just going to wait a minute while everyone enters. I've got just two people on camera, which it looks like that's fine. So I'll go ahead and welcome everyone. Let's see. Great. Good morning. I'm Megan Nyes. As you all know, I'm the hearing officer for the Administrative Hearings Office of the State Water Resources Control Board. This is a pre-hearing conference on the temporary suspension of Environmental Laboratory Accreditation Program Certificate 3092 of the laboratory, currently located at 3440 El Cajon Boulevard in San Diego. This pre-hearing conference is being held in accordance with the notice of public hearing dated March 8th, 2024, and amended notices dated March 15th, March 21st and 22nd, and April 11th, 2024, as well as the pre-hearing conference dated June 3rd, 2024. As I did in the last pre-hearing conference, I will use the acronym ELN to refer to the Environmental Laboratory Network, and I will use ELAP, ELAP to refer to the Environmental Laboratory Accreditation Program, and I will use the acronym AHO to refer to the Administrative Hearings Office. As you all know, this hearing is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and video are being recorded, and we will post files of this recording along with the Zoom-generated transcript to the AHO FTP site. The YouTube recording will also be available on the AHO YouTube webpage. If at any time you are experiencing technical difficulties trying to communicate with us, please send an email to the AHO at adminhearingoffice, adminhrgoffice@waterboards.ca.gov, and AHO staff will be monitoring the email inbox. Assisting me today are several staff of the Administrative Hearings Office: Nicole Mullen, Rebecca Stolfus, Kyle Waldridge, and Skylar Anderson. And then we also have Emily Roberts from the board's Office of Chief Counsel, as well as Chris Hand from the ELAP. And then these individuals are identified on page 5 of the March 8th, 2024 hearing notice in the section labeled Hearing Officer and Hearing Team. And then finally, if at any time I'm experiencing technical difficulties and I'm not able to rejoin the Zoom conference, one of my staff will call a recess until I'm able to rejoin you. So let's move on to appearances. Ms. Mooney, I'll ask you to please make your appearance and then also identify anyone else from the PT who's on the call this morning.
Good morning. I'm Laura Mooney on behalf of the prosecution team. I work at the State Water Board at the Office of Enforcement. And other members of the prosecution team that are with us today are Michael Head and Naeem Ahmed, Jennifer McLaren. They are all from ELAP. And also joining us is Robert Brownwood, who's the Assistant Deputy Director at the State Water Board's Division of Drinking Water.
Great. Good morning. Thank you for being here. Mr. Shepard.
Yes, good morning. Scott Shepard. I'm here on behalf of Environmental Laboratory Network.
And is there anyone else? I don't see anyone else from your team on the call, but just wanted to double check.
I don't see anybody else either.
Okay. And
I didn't expect anybody, if that helps.
It does help. Okay, great. So the purpose of this pre-hearing conference is to discuss the issues I laid out in the June 3rd, 2024 notice of pre-hearing conference. This includes an update on progress towards settlement or some kind of negotiated resolution, the parties' April 10th, 2024 written responses to the hearing officer's briefing questions, and then whether we need to make any scheduling changes and any other procedural issues the participants wish to raise. So is there anything else that I should add to the agenda to talk about this morning?
I guess there's a few items that I would like to add.
Okay.
I would like to discuss a subpoena that was issued.
Yes.
And compliance with that.
Yes.
Related to that is that we would like to submit supplemental evidence that as it relates to that issue. And I'd like to discuss, let's see. I just have one witness issue, very minor to address. And then just uploading some documents, i.e. rebuttal, cross-exam exhibits that might be used, but maybe not. And just some logistics about uploading things.
How to do that. Okay. Yeah. Okay, great. We can get to all of that.
I would add one thing as well. I've raised this with Ms. Mooney yesterday. My client has engaged a consultant to help with the accreditation amendment for change of location. And he may have some useful comments, so we may add him as a witness for Tuesday.
Okay, great. Okay. So I guess I'd like to hear from both of you. You know, I know you've been trying to settle this, and it's sort of tricky because there's the accreditation progress that the process that the lab is trying to work on, and these things take time. So, Ms. Mooney, let's start with you. How are things looking with, I don't know, where are you at with some kind of agreement here?
The prosecution team does not believe that there is any settlement of this
Okay.
matter that's going to happen before hearing, and we'd like to proceed.
Okay, fair enough. Mr. Shepherd.
We have continued trying, but the probabilities as we assess the wins, so to speak, I don't disagree with Ms. Mooney. I think we need to keep on calendar the hearing for Tuesday. We've moved it long enough, and
Right.
and our projections about things that would happen on a parallel timeline, not for any lack of good effort by Ms. Mooney and myself, but just hasn't accomplished. So we probably ought to get this thing addressed. It's the temporary suspension that we're dealing with, and so it has drug on at this point that we probably should move forward.
Right. Okay. So that makes sense. I'd like to lay out my understanding of what this hearing would be about on Tuesday. This is in the hearing notice. So the purpose of this hearing on Tuesday is to consider whether the February 20th, 2024 temporary suspension of ELAP Certificate 3092 issued by ELAP staff of the State Water Board to the laboratory formerly located at 9590 Chesapeake Drive, Suite 300 in San Diego should remain in place pending a hearing under California Health and Safety Code Section 100910. The lab has now moved locations. And so the hearing on Tuesday will be, and Wednesday, if we go over, will be a single issue, which is whether the temporary suspension of ELAP Certificate 3092 prior to any hearing on the merits pursuant to Health and Safety Code Section 100910 is necessary to protect the public under California Health and Safety Code Section 100915. And so my understanding is that there could be a second hearing on the merits. And I just wanted to confirm with both of you that that's your understanding of this process as well. So Ms. Mooney, and any additional comments that you have, I just want to make sure we're on the same page. So Ms. Mooney, you're nodding. Do you agree that that's the scope of the hearing for next week and that there may be a second hearing?
I agree with that.
Okay. And Mr. Shepherd, is that your understanding as well of what Tuesday's hearing will be about? Is this single issue of whether the suspension is necessary to protect the public?
I concur.
Okay, great. So I wanted to turn now to the parties' written responses to the questions that you submitted on April 10th, and thank you. Those were very helpful. And I particularly wanted to talk about question 2, because it seems to me that if the AHO does not, so if the suspension remains in place pending this merits hearing, which we just talked about, then ELN cannot operate. But if the suspension is lifted, can ELN test samples? And I'm going to, Ms. Mooney's response was pretty clear on that even if the certificate is, I believe you used the phrase legally active, Ms. Mooney, that the lab still cannot test samples. And so Mr. Shepherd, I wanted to kind of hear from you what your thoughts were, because it sounds like whatever the outcome is of this hearing, the lab, the way it seems to me, does not appear that it could resume operations on, whenever the water board issues an order on the temporary suspension. That's what it seems like, but I may be wrong.
So this is not a subject that has not been discussed before. Ms. Mooney and I have discussed it at length. The procedures under the regs for applying for a change of location amendment, in my view, contemplate continued progress. Let's see, how do I do this without getting too much into the weeds of the facts? Because I don't really need to do that. But I do think that, generally speaking, the lifting of the suspension very well may allow continued regulatory testing to go forth in most circumstances. I think the history here with what has happened since February 20th, which is the effort to get the accreditation and the amendment approved and it not being approved certainly creates some grayer area than my initial read in early March of the regulation would have suggested, right? There are timelines in the regs when things are supposed to be done, and we're now outside of those timelines. So without conceding a position, I'm mindful of the impact.
Okay. Okay. And so for both, I guess I want to sort of not to beat a dead horse, but just follow up. So, and I'll ask you, even though it may seem obvious, can you each provide for me what is your, I mean, and I guess, yeah, this is quite obvious, but what is your hoped for outcome of this hearing? Because Mr. Shepherd, it sounds like for you that there's some, you're under the impression that your client may be able to proceed in certain instances with regulatory testing. So what are you're hoping, obviously, that the suspension is lifted pending a hearing on the merits. Can you say anything else? I just want to make sure we're having this hearing, that it makes sense to have this hearing. So is there anything else that you can tell me?
Yes, there is.
Okay.
The relief of the suspension from an optics point of view for my client's customer base would be very valuable and important.
Okay.
Putting aside whether or not any testing goes forward, right? So,
okay.
Where she was in the stage and process of getting, so the amendment application process, was going on. Where she was in that stage, where we are now, a little different, but create a situation where, the optics to the public of being suspended are different than the optics of not suspended, but still trying to get this application approved.
Okay. Okay. That I understand that. And then Ms. Mooney, do you have anything else that you would like to add about, I don't know, for you, the importance of this hearing going forward and the outcomes, what happens after the order?
Exactly. I would like to be heard on that. The prosecution team, our hair is on fire when we hear a lab say that even though they're not in compliance and their laboratory is not accredited, they're going to do regulatory testing anyway. And that a 30-day relocation a 90-day relocation statute that allows a process when you relocate labs somehow only sets forth some type of timeline. What was the word? Yes. Rolling timeline. That's not what the regulation says at all. This laboratory does not meet ELAP accreditation standards. It does not have a certificate to perform analyses for regulatory purposes, period. And so this hearing, I think you can understand now why, and the arguments that are being articulated, why it is so critical that we need to move forward to ensure. And the optics of ELN and its client base is, I'm sorry, completely irrelevant. That laboratory does not meet ELAP accreditation standards. It does not have a certificate, and the certificate it is holding out as its own applies to an entirely different laboratory location. And we need to ensure, optics aside, that ELN is not doing anything to hold that certificate out as authorizing it to continue in business and do California regulatory work. It is so critical. And so I think you can understand now what we, the prosecution team, see, the criticalness of protecting the public from ELN, who, if the suspension is lifted, will be out there doing regulatory testing. And we submit we have evidence that it's done so even after the suspension was put in place.
Okay. Mr. Shepherd, any last word before I move on to the next topic? Okay.
Very briefly, just counsel said that we're asking to do regulatory testing. I don't think that's what I said. I haven't said that we're going to do regulatory testing, that my client's going to do regulatory testing if the suspension is lifted. I'm just saying that I think that the suspension being lifted may impact whether or not there's a prohibition on doing testing.
Okay. Ms. Mooney, I wanted to talk about the administrative subpoena that you served on the defendant, I'm sorry, on ELN.
Mhm.
So you described maybe you can tell us sort of generally, the problem that I have with this is that there's no motion before me, either a motion to quash or motion to compel, and we're really running up against our Tuesday deadline. So I wanted to figure out what we can do and kind of what the issues are. So Ms. Mooney, if you can sort of generally describe what's been going on with the subpoena that you served April 30th, right?
April 30th, 2024. And as you'll recall, the evidence submission deadline closed on March 20th, right? So this is evidence that came to light after the evidence submission deadline closed. And what we learned was that ELN had, in fact, after the February 9th ELAP inspection, and then again after the suspension went into effect on February 20th, that it performed analysis for regulatory purposes and California's drinking water program. So although we also discussed it with ELN, we issued a subpoena to get documents. So the subpoena, as you know, as briefed to you very briefly, is one, we want the native files for a disputed exhibit that ELN has submitted. And then two, it's this issue of regulatory work that was done after February 9th, because that is the day that ELAP was on site and directed Jenny to cease performing any regulatory analyses. So this evidence, what I want to have happen, when I want that there's still not compliance under the subpoena. For example, we do not have what we asked for is the native file for the disputed ELN exhibit 23. So that is a paper document, a PDF. I want the native electronic file. If they don't have it, then I want them to submit the required affidavit stating why it no longer exists. I want that statement under oath. So I would ask that you use your powers as the hearing officer, even though there's no formal pending motion, but this is a subpoena that's been issued in this matter, to direct ELN to comply with that obligation. Second category of documents, which are it's a series of requests, but very specific documents about any regulatory testing that happened after February 9th. And if I can have just a minute to explain to you the process, when a regulatory analysis is performed, it's not there's a result and I call you up on the phone, or maybe there's some kind of like a document exists. This is a laboratory. Work orders get issued. Lab analyses, printed documents get issued. Laboratories do this when work is done and analysis is done. So what I've asked for are those documents that exist. There's no dispute it exists. It's not like I lost it or maybe I didn't get it. It's the very foundation of what laboratories do. They generate a paper trail. And so that's what I've asked for. I think it would be very easy to produce the underlying documentation if, for example, has been represented, ELN states we subcontracted out those analyses to an ELAP accredited lab. If true, that underlying paper trail exists. That's what the prosecution team has asked for. So we have an ELN analysis submitted to the drinking water program that on its face shows that ELN conducted the analysis for regulatory purposes in the drinking water program. If the story is that they subcontracted it out, one, what they submit is supposed to reflect that. There's a regulation on that, but putting that aside, that the work was subcontracted out. But two, if true, then ELN has the underlying laboratory documentation for it. And that's what I haven't seen. And if it doesn't exist, that's fine. We'll deal with it at hearing. But what I have right now is ELN telling me I'm not quite done producing documents. So how am I supposed to be at hearing when I don't know what their story is? Are they going to show up and say under oath that the work was subcontracted out? Oh, but I didn't give you any of the documents? Or they give them to me on Tuesday at the hearing? The subpoena, which was issued back in April, has asked for this. And this is the documents I want. So getting back to your question, I again would like you to direct ELN to comply with the subpoena. And if they do not produce the documents, then they cannot testify on Tuesday as to matters that are covered by the subpoena, and yet no production exists. So well, let me say this. They can testify to it, but in rebuttal, I want to be able to come back and impeach them with the subpoena. Now, that's the part that's a little bit unclear, right? Because I don't know what they're going to say. I know what I've been told so far. So I've got two issues. One, I want to supplement my case in chief evidence to put in what the Division of Drinking Water has produced to us on ELN performing regulatory work after February 9th. Then two, I've got this rebuttal issue, depending on what they do and say at Tuesday's hearing, in light of a subpoena that's not being complied with.
Okay. So I think as to your first issue, which is whether you can supplement your testimony, that exhibit filing deadline of March 20th, that was optional. So you can submit any exhibits you want up till and including you rest, essentially. So,
Okay.
you know, logistically, it's probably best if you upload those to the FTP site and then we can screen share. But as soon as you upload those, we would move them over and they would become public documents that I would look at and that anyone could look at. So it's, you know, up to you to decide when to provide those supplemental exhibits and testimony, but you can absolutely do that. I'm going to hear from Mr. Shepard now regarding the compliance with kind of your second issue. So Mr. Shepard, you've heard what Ms. Mooney has had to say. So what's your response?
Sure. So let's go through a couple of things. Let's start with the first one, which we had these evidentiary submissions in advance of our anticipated hearing date, and we did have an agreed deadline for submitting those, and that's where we are. And one of the documents is a PDF for which she's requested the native file, and I've gone back looking for that, right, trying to see, you know, is that something that can be found? It's an email, right? So it's certainly something that could have been double deleted, and it's something that could have been in a draft item, you know, the outbox and never sent. And I don't have the answer to that. And, you know, to the extent that's part of our submissions, I think that's a cross-examination issue and it can be dealt with. This sort of on the fly at a pre-hearing conference, let's get an order to compel, I don't think flies, but I think, you know, if I can't produce that and I can't identify it, it has the impact that it has. I don't know of any requirement that says for me on this particular type of hearing on the temporary suspension that I can be, you know, put to answer essentially interrogatories, which is what she's asking for now. Here's a special interrogatory. Please identify whether you have this follow-up, you know, whether it ever existed, and if so, where it is now or what happened to it. And certainly, you know, in the CCP, there is that requirement in request for production where if you had it, you know, when you do your written response, you're supposed to do that. And we don't have that process, which really leads me into the second point, right? So this, in my view, the suspension on February 20th was a moment in time. And the question is, was there a basis to suspend this lab then to protect the public? And that's what they were prepared to put on then. We have moved it because we've been trying to go on a negotiated path. And while we haven't yet reached that, that's still the issue. There isn't a provision, as I read it or see it or understand it, in this temporary suspension proceeding to go do discovery. Now, that may very well be when we get to the next step, right? This discovery, this subpoena may be something that is pertinent to that hearing on the merits step, but it's not now. And I understand counsel's frustration, right? I mean, she's trying to get ready. She thinks she needs this stuff, wants this stuff. She said, you know, why she's concerned about it. And I hear all of that and I get it. But relative to, you know, my client who has been trying to go through an on-site assessment program, then found a consultant and sort of decided to move the on-site assessment program. Probably not more information is needed, but is now trying to get things really squared away and buttoned up so that she can get this laboratory accredited and do the proper regulatory testing, reestablish good relationships with the people over at ELAP, and just move forward from there. So relative to the discovery, we have produced some documents. They have not been, there are others, I am informed. But I don't think that needs to get addressed. I don't think that should be addressed as part of what we're doing on Tuesday. If there's some issues about, I mean, there's basic credibility of witness issues that always counsel can do, you know. Did you do this? Did you do that? Do you have documents? Where are they? You know, but I don't think that's our issue. I think the issue is frozen in time as of February 20th. Was this suspension proper or not?
Okay. Miss Mooney, please.
Yes, a couple of issues to hit on. One, there is under the subpoena itself and what constitutes compliance. There is an obligation for them to provide us with an affidavit in connection with the production. That is part of the compliance. So it's also provided right in the subpoena that's issued, which is that they must submit an affidavit in compliance with section 1561 of the evidence code. And the citation for that is Government Code section 11450.10, subdivision A and B. And I said that very slowly because this is exactly in the subpoena itself, which I can also, of course, provide to you. So if part of that obligation in that affidavit is if ELN does not have the records described in the subpoena or only has part of them, the affidavit must so state. And I'm entitled to that under the subpoena. It's just like producing a document. It's the same obligation. He says, Mr. Shepherd said that there are other documents. This is exactly what I'm concerned about. So when am I going to see them? On Tuesday, when we are questioning, and then, a witness, and then statements are made, and then what, a document's produced then? Is that when I'm going to see it? How can I cross a witness when I don't have documents that the prosecution team asked for back in April? One last point about this quote, moment in time, that we're somehow frozen and that ELAP, the prosecution team, is not entitled to any discovery. ELAP is absolutely entitled to issue a subpoena, and I've provided the citation, and it's in the subpoena itself. And this issue goes to the heart of whether there's a danger to the public. And I actually want to point out to you something that ELN stated in response to issue number 1 in the April 10th filing that we made. And they specifically said in response to issue 1, the salient question is whether ongoing or resumed operations pose a concern. The express representation has been made. ELN has ceased doing testing for which its ELAP certificate would be required. And it says, that's why we're going to continue the hearing, because we're going to do this parallel process and try and get the certificate amended, i.e., and it says, to provide assurance to the State Water Resources Control Board that the public is protected. And now I have evidence that the exact opposite has occurred, right? That regulatory testing did happen, that the salient question of whether there's ongoing or resumed operations is exactly what the subpoena is targeting at finding out. And it is directly relevant to whether or not there is a danger to the public if the board were to lift the suspension.
Okay.
Can I also one last point? The credibility of the witnesses is absolutely at issue when it comes to that October 23rd, 2023 email. So if that email was fabricated, that absolutely, that credibility issue and your assessment of Ms. Douglas when she's on the stand is obviously pertinent to the issues, including whether the lab that she operates constitutes a threat to the public.
Okay. Mr. Shepherd, any further response?
Yeah, thank you for that. Just a moment. I mean, I think what counsel said doesn't change my point, and it remains the same. The question is, was the temporary suspension then proper? And I didn't dispute whether they have a right to issue a subpoena and get their response to it, but the question is whether that's happening right now in this proceeding. There are procedural remedies for all of that. The issue really is was the temporary suspension properly issued at the time? And
Mhm.
they have the same reason they issued it, right, is going to be the evidence that you need to hear, which is the individuals that went on site, saw what they saw and did what they did and why they did it. Is that sufficient? That's really the standard. We don't get to go into a house, and then try to justify the warrant based on what we found. We have to have the warrant justified in the first place. And that's really what we're dealing with.
Okay. So Ms. Mooney, just to clarify, you do have some evidence that you said you've received some documents already in compliance with the subpoena. And you did mention, I think a couple of times, that you have evidence that there was continued testing after the February 9th, 2024 suspension date. Is
The
that correct?
February 9th, the February 9th
inspection.
date was the inspection, and then February 20th was that was the formal suspension.
Okay.
Yes.
I mean,
Yes, and I do have such evidence.
okay. I am concerned without a pending motion before me of just issuing some kind of ruling on the subpoena. I think I'm inclined to agree with Mr. Shepherd. I think we can go forward on Tuesday with the documents we have. Ms. Mooney, you have 4 witnesses that you're planning to put on. You have 36 exhibits. It sounds like you have additional exhibits that you'd like to put on. Mr. Shepherd, you have 48 exhibits. I think that this is going to be adequate for Tuesday to make the decision on the single issue that we have. And then you do have this second chance with the merits hearing if that ends up going forward, where you can continue to negotiate, to meet and confer about fulfilling the rest of the subpoena compliance requirements. And, please bring a motion, either of you, if you're running into issues with compliance at some point. But without a pending motion, I am uncomfortable ordering Mr. Shepherd to comply. I haven't even seen the subpoena. And there's nothing pending before me. So I don't think I'm able to provide further guidance, but it sounds like we're all in agreement that we're going to go forward on Tuesday. Ms. Mooney, you're able to provide any additional exhibits that you'd like to provide, because that exhibit filing deadline was optional. So is there anything else kind of on these topics that we should talk about before we move to some of the logistical questions that Ms. Mooney raised at the beginning of our conference?
That covers it for me. Thank you.
Okay, terrific. So let me pull up the hearing notice. What questions do you have so that we can be efficient and maximize our time together on Tuesday starting at 9 a.m. And we do have a hard stop at 1 o'clock on Tuesday, both days.
I did want to address, so with the supplemental evidence, we will be submitting evidence, and we'll do that by the end of the week, including to give you time to review if that's possible, just so that it will include written testimonies from 2 districts of the Division of Drinking Water. So in Imperial County and San Diego County, and the witnesses will authenticate records and going to this issue of post February 9th regulatory analysis performed by ELN. So just to highlight that for you, and so that Ms. Shepherd also has access to that evidence. We'll post that by the end of Friday.
And just a question, will they be testifying as well? They'll be providing written statements and testifying as well?
They will be present at the hearing as required. I do not believe our case in chief will be putting them on as testifying witnesses, but they will be there to affirm their written testimony.
Okay.
And be available for cross.
Okay. Okay.
Can I ask a question of clarification? So you said they're not going to be part of the case in chief, but are you suggesting that their declarations will be part of your case in chief?
Absolutely.
Understood.
So one logistical issue with a witness. So this is our custodian of records for the California Department of Public Health. And that written testimony, and Mr. Shepherd and I have discussed this, that's just a written testimony by CDPH to authenticate records, and it's just a pure custodial declaration. That witness, Travis Yu, has some serious calendar conflicts next week. So on Tuesday, he's actually out of the office, but he could be available between 9 and 10:30 a.m.
Okay, so let's plan to call him out of order then.
Yeah.
Okay.
So and I just ask, and Mr. Shepherd might not have a position on it, but since it's just a custodian of records, witness, I was wondering if he could even be excused from appearing. I don't think there's anything controversial in his and what he put into the record, but of course that's for ELN to decide, not me.
Yeah, Mr. Shepard, you may not want to speak to that. Maybe you need a minute to think about it, and we can certainly decide on Tuesday. I mean, that seems okay, but what's your thought?
I can't commit to not call
Okay.
him, or it's a him, I think I heard,
Mhm.
yet. Even if I don't have issues relative to his authentication of records, I may have some questions about places he did or didn't look, things he did or didn't find. So it may be, and I haven't studied his declaration, may be that when I
Right.
look at it, I have nothing, but I just can't commit right now.
Okay.
I have committed that I will work with counsel to make it convenient for him, because I don't expect, if there is testimony that would be significant or long.
Okay, I appreciate that. And I appreciate, the affirmation of you trying to work together. I know that that can be difficult. And I do appreciate all the work you've tried to, done together so far to try to see what kind of outcome we can have. So thank you. I appreciate that. Ms. Mooney.
All right, so we will also be uploading. So our case in chief, how we are going to do it is by using a PowerPoint presentation. So we
Okay.
will also be uploading that. Just to clarify then, does AHO staff then control the PowerPoint presentation itself? Okay.
Yes. Yeah. So we'll do all of the screen. That's a great question. Thank you. So we will do all of the screen sharing. And Nicole Mullen and Rebecca Stolfus from our office. I'm not sure which one will be handling the PowerPoint and any other exhibit sharing on Tuesday and Wednesday, but you can just feel free to say, Miss Mullen, can you please pull up, the PT slideshow, or can you please pull up, PT5 or ELN2 or something, and then they will pull it up for you.
Okay. Related to that then is my question about, I have certain exhibits that I might show on cross-examination. How should I name that file? Obviously I might not use them, and I might. And so how should I name the file and or refer to it so that your staff can pull up that exhibit and display it to the witness?
Good question. I'm not sure. I think just whatever as long as you signify in some way, this is a cross-examination exhibit and it's clear to our staff. So I don't know if you want to put that in the file name.
Yeah, I can do that. And also number it
think
that way so that it's at least clear.
Yeah, that would be, because they're managing so many documents. So we just want to make it as easy for them to find. So whatever naming convention you choose is fine.
Okay.
Can I ask a clarification there? I haven't gone back to see whether there's some different requirement that would change it, but assuming for the moment that I don't get the impeachment documents until she thinks she needs to use them, how will we arrange? Because I'm still entitled to see it before questions get asked, for an opportunity to make any objections if I have them. How will we coordinate that transmission if you plan to not send them to me in advance, Ms. Moody?
We do have I'm going to step in. We do have the break. So we could break, and then you could upload rebuttal exhibits. And then on Wednesday, the 12th, you would have had then several hours to review them. And then we could start the rebuttal portion of the hearing on Wednesday, would be one potential option. We could take a short, or we could take a short recess. You could review all the exhibits and then, resume the hearing.
Yeah, those are great ideas. It may be as simple that, I will have electronic access. So if she's about to use something, we take a 1 or 2 minute break. She can email it to me. I can see it. If I have an objection, I can say, and then we send it to you, maybe by email as well. The only key is I would not want to have it published on the screen for witnesses and other participants to see before we've determined the preliminary matter of whether it can be used.
Okay, Ms. Mooney, what's your response?
Yeah, it is a challenge with a Zoom hearing about, both you and Mr. Shepard reviewing the exhibit I want to use before I display it to the witness.
We do have folders for when we have sensitive matters, and we have certain documents that we are not ready to make public we do have a folder that we could direct you to put rebuttal exhibits into that would just be accessible to Mr. Shepherd and me to our office. And so maybe we do something like that. So would
Yes.
you, and I know you're going to be kind of making some game time decisions. I'm trying to think of the best way to do this. When will you, I don't know, you could just, I guess, email our office and kind of say, hey, I'm thinking of using these exhibits and I need to have them reviewed first.
There are instances too where I do not want to show some of the exhibits I would use to impeach testimony that I anticipate from Ms. Douglas. So
Mhm.
yes, while Mr. Shepherd is entitled to see it before I display it to her, I am reluctant to do that ahead of time and basically show my hand on how I
Right.
intend to cross-examine his witness.
Right.
I definitely intended to upload it to our folder and have it available so that it's used. I think maybe we'll just have to decide, and I'll keep this in mind as I think about how I do my cross-examination of her, that I've got this little technical hiccup about using a document with her. And so that I better show it to Scott at least, and or you, depending on what it is ahead of time. I think I just have to deal with that as I prepare for my cross-exam. Yeah. It's just the limitation of a Zoom hearing, and it happened a lot during course as well during COVID. So I will think about that.
Okay. Okay. That sounds good. What else?
Let's see.
I have a question.
Okay.
Is there a preference that everybody that will have a speaking part in the hearing have a dedicated computer? For instance, can I put my client in my conference room with me and we have one computer, or do you prefer that everybody have their own screen?
I think it's easier for the Zoom recording if everyone has their own screen. If you don't mind, I think what's helpful when we go back and also for members of the public, even though it'll be obvious when you and your client are switching, I'm thinking about the names that I see below, it kind of indicating who is speaking. So because also I wonder how that works with the Zoom generated transcript, if it's going to attribute your comments to your client or vice versa. And so if it's at all possible, my preference would be for each participant to have their own computer. If it is not, because I understand sometimes there are limitations, then we'll have to deal with it and somehow indicate, and I'll have to talk to my staff about, and we'll have some answer ready for you about how we're going to deal with this. If you're both in the same room on different computers, that can be just a FY, that can be an issue with like feedback and stuff if one of you is speaking and her computer's on. So I can understand wanting to just use one computer and sort of pop in and out with musical chairs, but there are some issues for the record, I think, that I'm thinking about. Is it going to be possible for her to be on her own device? And do you think, or?
I wish that I could tell you that I'd thought of this before this hearing and talked to her about it. I assume so, but I don't know yet. I will think on it. I will talk with Ms. Mooney as well offline, and I'm sure we can come up with something that's sensible.
Okay. Great question.
Those were all the issues that I had that I would like to address.
Okay. Mr. Shepherd, anything else from you?
The only other one I have is the gentleman's name is Gary Ward, is the consultant who I think I may be adding. I'm asking to add to my witness list.
Okay.
I'm not recalling now. Do you require written direct from all witnesses? Is that a mandatory, or can I have someone come in just, I mean, I'll comply with either way, but I just didn't require whether that was a mandatory versus a strong suggestion.
Yeah, I don't think he needs to also provide a written statement. He can just appear and testify. I think the regs are if someone provides written testimony, then they need to be present to confirm that this is their statement and be potentially available for cross-examination. But I think if he just wants to come testify, I think he's able to do that.
Okay.
I'm glad this issue was raised because I am just a little bit in the dark, one, about who the witnesses are. And entitled to notice, at least, of who is going to be part of ELN's defense. As I understood it, it was Miss Douglas, and now it's Gary Ward. I mean, I don't even know anything about him. Am I not entitled to at least know a title? I mean, who he is ahead of the hearing? Do I just go into it blind?
I mean, I think these proceedings are a little more informal and so I don't know of a requirement that you need to have a witness list. And I don't believe in our hearing notice, we also required a witness list. So I think he's given you the name, you know, you can leave you to your own devices of internet research if you need to.
I guess that's what a break and rebuttal time is for. I look forward to it.
Okay, great. I'm gonna just check that I don't see any messages from staff. So we will reconvene Tuesday. I don't see anything from staff. So, you know, continue to check your email, continue to let us know if there's anything that changes or you have any questions, just email the service list if there's logistical questions you would like an answer to or any other way that we can be helpful. But otherwise, I guess we'll see everyone bright and early on Tuesday, June 11th.
Great. Thank you for your time this morning.
And thank you. I have one technical question, which is, it's still going to be the Zoom link that is in the most recent published notice, correct?
Yes. Yes.
Right.
Yeah.
Okay.
Okay.
Thank you. Appreciate it.
Thanks, everyone.
Good morning.